White here.
York here.
Talbot here. Perry here.
Right here.
To confirm there is a quorum.
Yes, sir.
There is a quorum and we have confirmed it. Let's go to special events.
We have, four different groups that are doing special events and they're on your agenda. Shelby Baptist, August the 7th and 8th, which means we need to approve them today. Team Small, September the 18th, Maps, October the 24th, and Giving Back at the Community Clinic on September the 11th. And all have asked to have their fee set at the dollar mark. We just need to vote on them, whether we approve them or not.
All right, Mr. Youngblood, anything to report on these?
No, sir. A lot of these have been having ongoing events through the year. Like Shelby Baptist Association, they have a mobile unit. They keep it up to date and they take it where they go. Team Smile, this is a yearly event that is in cooperation with UAB. It's a pretty big event. Been on the phone with them quite a bit. Looks like they're going to be bringing in 30 portable units. As of right now, they are up to date with us now. They will have to renew them for next year. So all these events have been going on for a while. NAPS has been going on as well, and they've had really good turnouts over in the Selma area.
Do I hear a motion?
I'll make a motion.
A motion made by Dr. Piszczek for the listed special events, and they're all charitable. Is that correct? And with the minimal payment. Second by Dr. York. McElwain, yes.
White, yes.
York, yes.
Piszczek, yes.
Talbot, yes. Perry, yes.
Gray, yes.
All in favor? Okay, now let's go to our work sessions on the DPA.
If we should pick up somewhere where we left off, want to go back a smidge, we can for Dr. Gray. Most of what we covered last time fell within the first 10 pages for the definitions. So I think we're picking up on page 12. I printed the packet for relevant. So that's the big one. Yeah, that's the one.
So we're on page 12.
Ish. Yeah. We're right now.
Yeah.
Where my notes tailed off. And I didn't remember whether or not we completed page 9.
That's where mine.
Fair enough.
So, yeah, you're wrong. You didn't have it.
But we can pick up at 10. It's in the pack.
10.
Yes, sir.
Yeah, we went over this.
I remember some of it. I had notes specifically from Dr. York, and then there were definitions where we decided to accept a portion of what Dr. Talbot stated, but I did not have a specific note as to whether or not we were accepting Dr. White's notes. In other words, the portions where D, E, and F as an example versus Dr. Talbot's portion where it needed to be fleshed out a little bit. I do remember talking about the general differences between Texas, Georgia, so on. So I don't remember us coming to a conclusion. So if we want to start there with comments, Dr. McElwain, Dr. York can do his portion again in part A, and then we can just take it from there. And I have notes ready to go.
The new language would be D, E, F, and G. On page 10.
Dr. I think what we're saying is Dr. White proposed some language on page 10.
Right.
And that's A through G. And then Dr. Talbot proposed some language on page 11. They're similar and they
Right. And I think we kind of settled on Dr. Talbot's. Hers was a little,
And anything in black is current,
That's the current language.
And then I color coded everybody's comments.
oh, do I have three?
I think I made your remarks white, actually.
Yeah. When you pass it, it can say anything.
so do we need to read this out aloud again? Or, I mean, how do you guys want to do it?
Where I left off, I have a detailed note that there are portions of Dr. Talbot's position that for definition purposes, that's all on page 7A. But I did not have a conclusive note that we were accepting. So we wanted to go ahead, like we did last time, read it. The first person has a dog in this one is Dr. York, because he has, is qualified as a hygienist, too ambiguous. We want to just do that and address that. I'll
Okay.
take note to that.
All right, Dr. York, what do you mean there?
I think what I was asking was qualified dentist and hygienist to ambiguous.
That's on 3492.
You know, I just, it just seems that we're trying to tighten up some of these definitions or whatever definition parameters are. And I guess to me, I think I know what we mean by qualified, but we keep referring back to say, well, what does it say in the DPA? Well, maybe it does need to be a little more succinct than just that broad thing. I don't know. I would.
Why wouldn't it say license?
That's what I would think.
Would that be better?
It would to me, yeah.
Okay. Let's strike qualified and insert the word licensed in both places. All right.
Can you have a license but unqualified dentist?
No.
You can't imagine a situation where somebody's licensed and suspended, like a regular person may be, in a sentence that they're serving.
Maybe the license in good standing.
No. That's what my head, that's what my head.
Can I read the whole sentence? Can we start to see what it sounds like? They're gonna get yelled at for not having my microphone on. Okay. It is further declared to be a matter of public interest and concern that the dental profession merit and receive the confidence of the public, and that only licensed dentists be permitted to practice dentistry and only licensed dental hygienists be permitted to practice dental hygiene in the state of Alabama.
I didn't get what you're saying, yeah, about, if it's just suspended, the license is suspended or under review or whatever. And they're still under license. Should still license.
I think that goes a layer deeper in the onion, though.
Yeah, so if it says license.
The broader topic is that you can have a licensed person who is serving some form of probation, some form of suspension, some form of something. They've not lost access to their property right. That is their license, because you've not revoked it.
Right.
So then the question becomes, do we want to have a definition that is, not a definition, I'm sorry, but a sentence that is structured in that vein?
Is everyone good with the good standing? Because we could revise it just to say, and that only dentists qualified and in good standing be permitted. Just switch the order a little bit.
We were trying to get rid of.
But what if we said license?
I'm sorry.
Yeah.
License and in good standing. Correct.
Okay.
That's, yes. Only dentists licensed and in good
And
standing.
dental hygienist licensed.
Correct.
in Good standing.
Yeah, I have to.
Okay. All right, let's move on.
Okay, that's me then. Okay, this was to address the access to care concern. This is the legislature further, it would be a subsection D. The legislature further finds that access to oral health care remains a critical need in many communities throughout the state, particularly in rural and underserved areas, and that expanding access through innovative care delivery models is in the public's interest.
I don't have a problem with it.
Isn't that where my
Yeah,
kind of jumps in? And I
uh-huh.
think my point was that the current language interprets the board as only a disciplinary agency. And I had included several different states that they read, the board protects the public while promoting access to oral health care and a competent workforce. So it just broadens us a little bit more from being just a disciplinary agency. That also includes the wellness committee.
Yeah.
Because we're more than disciplinary. Since that seems to come up a lot on what our function is, I was thinking that should be defined a little bit better and what we actually do.
Well, as you promote access to care and ensure a competent workforce, whether it's through licensure, credentialing, or the wellness committee, you are protecting the public. So I think it absolutely should be in there.
Agreed.
Yeah, I like yours better. Yours seem to be,
But don't we have it, we also have a regulatory agency? I mean, we're disciplinary, sure, but aren't we?
Well, I think I have like A, B, C, D, and E. I had protection of the public, access to oral health care, modern delivery of dental services, professional integrity, and balanced regulation.
Bounce rate, yeah.
So that kind of hit those. That further goes on. Yeah. Supports professional standards of practice. I think I was just defining it again. Encourages innovation in dental care delivery, maintains fair and transparent regulatory processes. It's just explaining it just a little bit more. Whatever.
Kevin, is this an opportunity for us to say something about, while some of those goals that Dr. Talbot said, those goals are accomplished by education?
Yeah, Reagan is not here. Unfortunately, this is coming back to me more, getting back into it. This was the part where he planted his flag and said that this section specifically is for the legislative body to tell you what your mission is. I recall his point being something to the effect of, you can make suggestions, and I've made notes of them, but ultimately that's where the legislature will say, this is your prime function. And if you want that broadened scope, there may be another place that is better to put those stated goals. And then education, of course, would participate in kind with that. But is that your recollection too, about Reagan's statement?
I think it was.
He did say words to that effect, but I mean, all of this is a suggestion. It's ultimately up to the legislature anyway,
Correct.
so we can
Correct.
advise on.
I'd rather ask
Yeah.
than not ask.
But I would say I would recommend it. Does make it. It's better for that to be in there because this is essentially saying this is what this board is responsible for.
Correct.
We kind of answer that question, that we're not outside of what they're intended us to do.
Right. Well, but you see, my point being that we're involved in the education, but we need to make sure we have the mandate.
So when you say it, just, I'm hazy on it. I'm not arguing. Say-
Well, we conduct the ADHP.
Okay. Okay.
And I envision in the future, where the dental board might involve itself in promoting, education for anesthesia.
Okay.
Or
That's it.
safety.
Yeah.
You know, and we might foul up with Allen and have a program that could be something that could enhance dentistry and safety.
We already do a program for infiltration that's outside of the ADHP, so I do think that we need to add it.
Well, we formulated guidelines for what that program ought to be. Okay, so what we want to do is we want to flesh out Dr. Talbot's, I think we want to keep the A, B, and C. But then we want to add the other.
So that would be
So you're,
No, that,
we would remove your, because it's already a substitute.
Okay.
And then
Sure.
we pick up on like your C.
Yes.
C and D.
I'll read them, but we'll read them.
So A and B are already there.
Yeah, I think
But then you
you're,
would also include
We just make
education and
sure
wellness.
that we do address access to care,
Mhm.
because the legislature sees that as something very important.
I'll do the re-lettering of it, but A, B, and C are staying. And then I'll just retrofit Dr. Talbot's B, C, D, E, so on.
Right, and Dr. Talbot's B, C, D, E, part of Dr. White's, some of Dr. White's words are applicable.
Do you have specific ones of those that you'd like to consider?
Well, modern delivery of dental services, and Dr. White, in E, emerging technologies, teledentistry, digital health tools. See that?
I do.
Okay. Now, in here, Dr. White mentions expanded duty dental assistants,
I scratched that. We
but
talked about
I think we pulled that out because we really don't have anything defined there.
I kept it just for the conversational point because that banter has went across many members. But the gist of it is that this would be the opportunity to either consider it or let it go for the next, however long.
Yes. I think wasn't the point that if it was ever considered in the future, then it would already be there?
Yeah, the
Then you
rea-
don't have to ask for it again?
the reality of it is twofold. The current DPA has it because it was simply forgotten.
Correct.
It was not, there was no contemplation for it. It was simply forgotten. But two, there was conversation, at least in the recent past, about whether or not that was an endeavor that was going to be considered. And then, yes, to your point, if it were going to be considered, yes, you would want to have something there so that you could then build the rules to do it. But that is a much larger conversation to that topic.
Didn't we also say though that if it's in there and we're not acting up on it?
It opens your question.
Yes.
Yeah. Mhm.
Okay.
So again,
And that's the reason we took it out.
That's the reason we said we were taking it out.
so as long as everybody's on the same page and it can come out sort of once and for all, that's it. Their
Yeah.
expanded duties.
I mean, board, I would favor leaving out EDA language, at the present time until we reach a consensus about what we'd like that to look like in the future. And then it's gonna be a statutory change and a rule, when you get there. Because I don't think there's any consensus among dentistry about EDAs in Alabama right now.
Well, it was done once and kind of died on the vine.
Well, because we never could come to a consensus about what the hell they were gonna do.
Yeah.
All right,
It's still confusing for me.
it is because EDAs are used in different ways in different states. I mean, up to and including cavity prep fillets. Okay, so you got your marching orders on that.
I do.
Can I ask a question? And it's going backwards. So on page 4, the definition for infiltration, can we just make sure that covers all types of anesthesia, whether it's infiltration, block? That's just the definition for anesthesia. So that covers all kind of anesthesia. Am I correct?
I'm good at that.
What number?
It's number 7 on page 4. Yes, I'm talking about like true infiltration that hygiene students learn to do and block anesthesia. Does that cover both of those?
Infiltration anesthesia in this definition does not cover all.
Okay, how are we gonna cover blocks in this?
What page we on?
4, number 7. It's the last one on the page.
Perhaps it can be addressed under number 12.
Do we want it addressed? Is another question.
I want it addressed.
It's 412.
Yeah, so it's page 4, number 7, or page 5, number 12.
What do you want it to be? What exactly do you want?
I want to address it because I'm working with Dr. Beth Lewis right now to see about having a hygienist be licensed to do it. And it's very early.
And so this does not isolate dentists and hygienists.
So that's what I was asking. I just wanted to make sure it was covered. So we wouldn't have to come back to this.
You're gonna have to come back because you're gonna have to seek a statutory change. And this is statute, so you're right, this is where you change it, but you'd have to have a consensus of the board that that's what they wanted to do.
You would make it number 8, by the way, to bury the drama of where it needs to go. It needs to be number 8, because what I'm understanding is that block anesthesia or block infiltration, however you phrase that technically, would be the next step above an infiltration.
So number 7.
So it would be number 7 would stay alone, and then you would make
Okay.
a new number 8,
Oh.
which would be what you're suggesting, and then you just bump everything else down.
Hmm.
So Ms. Perry's point is that currently the infiltration anesthetic is something that dentists do, and then of course it's something that a hygienist can achieve permitting to do. And then the difference is that a block is by definition different than this. So the idea is to allow for a hygienist to attain a permit to that effect too. Or perhaps if
A
this
block
gets
is
changed.
local anesthesia.
It is.
I'm still confused. This does not say a dentist has to do local anesthesia.
Okay.
This is just a
It's
definition.
a definition.
Correct.
So
Yeah, I just want to make sure.
Because you can take that definition and it's
right,
part of your duty for a license. As long as they're defined here what they are.
So where does 7 not include a block? Are you reading it because of the terminal?
Well, I'm just reading submucosal.
Yeah, okay.
Okay, I mean, because submucosal is different. See, a block, you're penetrating through the mucosa, through the muscle, down just above the periosteum and injecting.
See, I agree. I was just reading it as we're in a terminal, peripheral sense.
What?
You can do that consonics.
Oh, yeah, I've done that.
I mean,
Yeah.
and my take on blocks,
On the outside edge.
this is just me personally, my soapbox on blocks. I try to minimize it whenever I possibly can because they do have complications.
Yeah.
Compared to like PDLs and local infiltration. So even our associates at a dental school, I really try to get them to only use blocks when absolutely necessary. You end up with numb tongues for a little while, you end up with trismus, you end up with hematoma every once in a while. It's just not worth it.
I agree. But what my point is there's 127 slides on block anesthesia that are currently being reviewed and looked at under the infiltration program. And my understanding is they do allow these students to perform a block before they get their license.
Well, I,
So if we're going to
Yeah,
teach it,
Yeah.
we're going to need to really teach it. We're not going to need to just give them 127 slides and say, show me how to do this, right? So if they're going to allow that in that program, they need to teach it or take it out. Either way is fine with me. It just needs to be, we can't just say, okay, show me one. Even though the girls know or the licensees know that they can't perform it, I don't think they should even be showing it if it's not something they're going to do. And 127 slides is pretty excessive to not be able to do it. Agree.
Are those slides teaching anatomy on that? On the 127?
An email of those slides, if somebody wants to, I'll send it to them and let them print it off. My understanding is some of these blocks have never even been performed by the very dentists that are in the state, but they're showing slides and trying to teach these hygienists this. Now, have I,
Go ahead and send the slides. Let me look at it.
can I send it to you and you print it off for us? Okay.
Okay, how about I propose this definition of nerve block? A nerve block is a dental procedure that involves an injection of an anesthetic or other medication around a specific nerve or group of nerve to temporarily interrupt the transmission of pain signals, providing pain relief or diagnostic information.
but look, did you see what the local, it's just a shorter version of what you just said.
I know, submucosal.
well, number 12 doesn't use the words submucosal, but number 7 does.
Right. So local anesthetic is the elimination of sensations, especially in pain in one part of the body by topical application or regional injection of a drug.
It's kind of covering everything
Exactly.
from block to top on 12, it covers everything.
I think that's adequate. Then the 12?
I do.
Okay.
I mean,
I'm just saying, if you want to put a definition of nerve block, I just gave you the
Right.
textbook definition of nerve block.
I think more of what, and I don't want to speak for you, Kelly, but I think more of what you're concerned about is having a pathway for hygienists to at least be in the conversation for giving these blocks.
Yeah.
And this does not make them not
Right. I
in the
just
conversation.
cleared up. I just wanted to make sure since we're doing this and it'll be 50 years before we do it again, I didn't want to, you know, I just want to make sure that that's covered because maybe not in the next 5 years, but who's to say in the next 10 we aren't doing it? Just wanted to make that a little smoother.
All right, can we, real quick on abandonment, because this has come up, are we on to that portion yet? All right, what do you,
What page? So he's on page 5.
yeah, just going down. Or, and I've gotten this question before, so you get a patient that's verbally abusive or very combative, and it's really not safe to have them in the office. You get them out of the office and you want to dismiss them. Okay, and so you're left with this 15-day period, and I get it, you don't want to just kick them to the side of the street, but at the same time, you really don't feel comfortable with them coming back in the office because of their past behavior. So do we need to consider that? And do you understand the problem that I'm seeing here? Like, what do you do with that patient? I mean, I know you can take them on the phone and just refer them, but you really don't want them in the office because they're actually a physical concern. And so are you forced to just say, well, come on in and I'm just going to roll the dice and hope that I survive? I mean, some of these people have threatened, drive through the brick wall. I mean, they get nothing. You won't give them narcotics. So they're going to post it. Yeah. Right. So that's my question on abandonment. And we want to touch on that to give an outlet just simply for safety of the practitioners. I mean,
Perhaps we should say, what if you deem the treatment of this patient is unsafe,
then the abandonment doesn't apply. I mean, I don't know. But,
Right,
but here's the question. You know, the two dentists in,
Texas,
Texas got,
right, they were
they got
killed
shot.
over dentures.
Yes, because patients didn't like the way the dentures fit.
Right,
I mean, literally.
and
yeah.
they gave them the denture.
Yeah, so my point is, I think we need a little bit of leeway. I mean, I get the intent of abandonment, but I also don't want to box this in so much that somebody's forced into a situation where it's really not safe.
I actually had a phone call about this last week from a dentist in Huntsville. They see that they do a lot of extractions and immediate implants, and so their clientele are people that have been life challenged in the past, or life challenged. Pulled out the statute, read this to him, and he said, does that mean I've still got to see them because they kind of made threats? And I said, all I know to tell you is if they made threats, I would probably try to get some type of documentation legally through law enforcement that if you do not see them or they make an issue about it, you could show that you had actually pursued this to a certain degree legally. I don't know if that was good advice or bad advice, but I also told them too, I said I would get that certified letter out today and cut your time down as much as you can and hope that those 15 days go by pretty quick.
So you've seen the point that I'm making.
Oh, I've never thought about it till he called me last Wednesday.
Cameron, what's your thoughts on this?
Well, that's what that's for.
I'm getting them onto the same portion right now. We're trying to catch up.
Kevin, it depends. I mean, I think you could create a defense and figure out where it would be at, saying patient abandonment does not qualify if you, whatever, and there's an emergency situation which you could document. It essentially provides a defense. I didn't abandon them because of this. It gives you a defense to put up.
Right.
But
You
But you
deem
could do it.
physical harm or
Yeah, if you're in immediate physical harm or whatever language y'all want to come,
You
but just provide it
perceive.
for them to say, I couldn't do it. I didn't abandon them because they said they were going to come shoot the office.
And Cameron, I've had a few more days to think about this than you guys have, but what I told him is, I said, the reason I think you may need to involve law enforcement is because all of a sudden, if I claim I felt threatened, but there's nothing to stand on, and Roberto goes, hey, John did that. I don't want to see this patient again. So I'm going to say I felt threatened too. And so I kind of felt like there needed to be something a little more backbone there than just my opinion or Roberto's opinion.
I thought this was already contemplated enough. I appreciate the point, but you're not a, how do I phrase this? You have 15 days to send them a letter. And the way that Donna always taught this to me was that you leave them in a stable state. And that's defined as a practitioner, you know that they are in a stable state. After that, you don't see them again. If they call you and say, oh, it's a little sore here, and you know as a clinician that it's not a medical emergency, it doesn't require that you bring them back in. It says that you only see them for medical emergency. And then there's the other portion of this, which is if you do deem yourself to be at risk or how your staff is at risk, this board has prosecutorial discretion too. So if that person were to file a complaint and you go through that investigative process and you find out that, dang, this guy was going crazy and was threatening to shoot up the office, you don't charge them with abandonment because that doesn't maintain or jive with the entire predicate that you've set up. So when you're making the definition, just realize that there's going to be an exception to virtually everything that you're doing. And you're trying to be as Dr. York said, as inclusive and as in total as you're achieving for, striving for. If there's something that was missed there, to Dr. Gray's point, then do you want to have a sentence or something added? By all means, just let me know and I'll type it and we'll grow.
Kevin, is it 15 days from when you mail the dismissal or 15 days from when they receive the dismissal?
What is remind me of the court rule? Is it 15 days? Doesn't include weekends, or is it 10?
If it's 10 days or.
Yeah.
This is for Alabama State Court. If it's 10 days or less, then it's business days. You don't count holidays or weekends. If it's more than 10, you just do a straight calendar, count the 15 days. If it ends on a weekend, you go to the next day.
Oh, this is.
But the question is that from when you mail the registered letter or from when you get the return receipt and they receive it?
It's.
What if they know?
What's it say?
it just
Because the statute doesn't say here.
Right.
I think I looked this up last week, and for whatever reason, I may be wrong, but I'm remembering that was on the date that it was mailed.
We've treated it as postmark day.
Okay, yeah, that's what I think I read.
I agree
read
with
swear
that.
to that.
I mean, I tend to agree with what Kevin says. If it's a safety issue of that magnitude, now you get into some subjectivity, but if it's a safety issue,
Don't see them.
I'm not sure, Don Harris was not going to see them as a lawyer.
What
or-
John said is exactly accurate.
Yeah.
The reason you involve law enforcement is so they write an incident report that puts a time and a date on the problem and quantifies it with a third party. It's not he said, she said, then law enforcement has put their signature on it.
Maybe use that as the backbone of getting out of the panel.
And also making sure that, to your point, great, that it's written in the chart.
Should that be addressed in this?
I think, we have abandonment written up in a pretty good write-up in the rules.
I heard Kevin say that he thinks you think we're covered pretty good with what we got, right, Kevin? Yeah, I don't disagree with you at all.
Are we replacing the language with the termination of dental treatment without giving the patient reasonable notice? Generally, at least 15 days prior to, or are we leaving it the same, termination of dental treatment without giving the patient adequate notice?
I think, remind me, but my memory of this one is that we decided to not use the new language suggested because we were not able to hone in on what reasonable was, and then what, I know that it's part of the justification, not the definition portion, but what reasonability and flexibility actually mean.
Okay.
What about instead of saying we want to change the word adequate, how about documented notice? Or just say notice?
Because the only reason why you're putting adequate or reasonable that would give me pause is you're saying it might be 15 days, but it could be more. Which I don't like that. I'd rather 15 days.
Okay, just
15 days
notice.
are good.
We used adequate to show that you actually have a memorialization of that from your practice. You couldn't just say that you sent Kevin a letter. You'd have to have documented in your chart that you sent a letter on blank date, blah, blah, blah. And if it was certified, you'd have the green card and the receipt appended to that later. I was here when that was going on, but that was the whole reason for adequate. If it needs to be changed, that's fine too. But that was why.
All right. So we'll pretty much stick with the definition we have there. Now, all right. Back to, where we were. On page 9.
No,
No?
sorry. This has come up, and it's just, I think it's prudent, and don't shoot the messenger. That's all I ask. I think it would be beneficial for you all to come up with established definitions for your licensing statuses. There is no definition of suspension or probation or blah, blah. And I think it would be reasonable to come to the consensus on what those mean, so that when they're used throughout the chapters, that you have something to go back to.
Do we have a list of those?
We can get a list of those. We do not have a list of them right now, but you have stuff like suspended, probation, expired, retired, if you want to add that in the future. Right now, we have a thing for that. Yeah, inactive, what that means, so on and so
Is
forth.
there a drop-down list on, that'd be a good place to start, because we don't have a definition for everything that we can drop down and set somebody's license to.
Right.
To his point, it probably needs to be done.
And a lot of those were put in when people just happened to think about it, so it wasn't statutorily documented.
Yeah.
So,
We have two people and different situations and they both have the same license status.
And there's some folks who just want to show that it's retired, not expired, not suspended, but just retired.
Right, and I do think we need to, it's somewhere in here, I remember this came up in the past when the word suspended in the DPA is used way too
Yeah.
liberally.
Back,
And you can end up with a suspended license when it really, you haven't done anything wrong.
It should be expired last.
Should be expired or inactive, one or the other. I don't care which one, but not suspended. And I don't know where that is, but we need to make sure we cover that base. I guess fast.
Mark, why don't we go ahead? Possibly Kevin shoot us an email next week with all these words we need to define instead of sitting there and trying to do it on the fly. And us send him our definitions and we can kind of mull this over again in the September meeting.
Okay.
Because I think we're going to get bogged down a little bit right here.
Oh, I didn't. Yeah, 100% agree. We'll do that.
Okay.
Did not intend for this to be
No.
an extemporaneous thing
No,
to do. But I also wanted to point out when I had the shot, it's probably not doing this in September. We have hearing on Thursday in September, so this wouldn't be happening. And then we have business on Friday. Unless you want to do this on Friday, that's up to you. But we could take it back up October, November, whenever you decide next.
Perfect.
All right. But let's get all of those that need to be defined down. Let's at least have what currently is in the DPA and rules about them, so we know.
So are we nixing 21, just getting, or are we leaving it in or out? Doing this definition. We're just gonna-
Yeah, I think it's got to go.
Yeah, we're taking it out.
Okay, I think we're on page nine.
That's the rule start.
Maybe,
All right.
maybe.
we're in. Well,
And this is where we license in good standing.
Yeah, we did that. My document
Changes. I'm taking extemporaneous notes, so my pages are not the same. So you just tell me where you're at. I'm following through in the sections that we're in with the notes that you're doing. But I have everything that you've said down so far.
Okay. So, and we were working on the legislative finding and we decided what we would suggest would be the legislative finding.
Yep.
All right. So then we're to license or permit required on page 12.
Yes, sir. That's right.
Yep.
Oh, this is about teledentistry. Okay, let me read Dr. Talbot's because I think hers is better again. Those providing dental services through teledentistry to patients located within the state provided. So services are performed in accordance. And let's see, no person can practice. Often holding setback. There was one that you wrote, oh, here it is, teledentistry remote supervision. I think this is just more direct, yours, Dr. Talbot, where you say teledentistry, remote supervision, digital dentistry, interstate licensure, portable care models are not addressed. And I mean, we just need to define them and put them in there.
I think that part's just an aside where those need to be defined in the definition portion. And I think the section 34-9-3 was just defining who is allowed to practice dentistry.
So am I fair to say that interstate licensure would be like the compact?
I don't think they're part of the compact.
Could that possibly be around the corner with hygienists?
I don't think it,
But
the compact is not just with hygiene, it's with dentists too, and that's just something Alabama has not jumped on board with. I don't know how far you are into the process of doing that. I don't think it's even on the radar. But I would also say that interstate to me means if they're licensed in Mississippi and they're accredited, then they come to us. We don't have the same problem as other states because there's no ADHP. So if they come from another state, they work Dakota. And so that to me is interstate as well, not just,
when I was just thinking of the situation where the girl ADHP is gone to Mississippi.
yeah. But Mississippi doesn't have an ADHP to bring to us, so
Correct.
we wouldn't have to worry about
Okay. Well, I
credentials
just
there, I
didn't
don't
know.
think. So I think that that's just interstate to me, again, would be anybody outside of the state of Alabama coming in would be defined under that.
To this point for discussion, that last line in Dr. Talbot's portion, is that something that we want to make sure is addressed appropriately in the definition section, or is that something that needed to be fleshed out, or you wanted fleshed out as enumerated, as Dr. White did?
What, the part about there are no expedited, provisions?
That, yeah, that part along with the next one, because there's the contemplative discussion about interstate licensure.
The interstate licensure probably needs to be in the definitions. The rest of it is, it already is.
Yeah.
Portable care models, what does that mean?
I don't know. I do not recall it this time. I was
Would it
just,
be mobile?
I think so.
Okay. Special purpose license, doesn't that cover, the people outside the state that want to do teledentistry? You know, it's a 3-year, right? Non-refundable.
That's what they.
I thought it was, for people who do, free dentistry or, missionary work.
I think so too.
I'll look it up again. In my mind, I thought that, huh?
I said, I'm not licensed, I'm the enforcement guy, and that's not my wheel. I know what you're talking about is
I know what you're talking about is the folks who do like radiographical review out of Connecticut for,
Right.
yeah, that type of stuff. I knew what you were thinking, but I was just trying to find the applicable term for that.
Dr. Talbot, I will say, it might make more sense to do what you're trying to do there.
It needs to be in there.
If it isn't defined, define it in the definitions.
Right,
but
that's
then-
what I meant.
But then turn around and put it into 3496, saying what constitutes the practice of dentistry.
Okay.
To say that teledentistry is, that way you're looping it in that you need to be licensed if you're doing this in the state, not. Because that's essentially what you're trying to get at. Make sure that's covered and it's not a loophole, correct?
I think when I was doing my research, I was just putting research down wherever I had thoughts or wherever, because a lot of it, was asking chat for their
So the-
opinion.
Under section 34.9-3, where I've written number 4.
Yep.
Would that not work?
I thought that the special purpose license addressed teledentistry for people outside the state of Alabama who wanted to do that. And it's a 3-year license, $450. We have all sorts of things. See, I thought we'd hashed that out a long time ago. Does anybody remember that? Or am I the only person? Could have been, that could be a fat embolie in my brain.
I'm not gonna leave you hanging. That's not fair to you, because that is true. It was discussed. I'm just trying to figure out.
I just remember spending a bunch of time talking about
Sure
it.
as hell did.
And we came up with a way to do it.
Yeah.
And, like beam readers who reads people's CTs.
Or oncologist, I think,
Right,
or
or not.
pathologist, or whatever. that
Looking
you
at
do.
slides.
Yep.
Okay, but I got,
We're sending stuff
I got a
to
question.
Kentucky.
If a licensee that's not licensed in Alabama remotes into my workstation and looks at my CT or looks at my radiograph and gives me a diagnosis, if he or she practicing dentistry without a license in Alabama, they're remote in.
Yeah, the whole contemplated purpose was that the non-resident, the Kentuckian, the Mississippian, the whomever, would have to have something to treat the Alabamian. When the Alabamian goes into their jurisdiction, their board's rules and laws are applicable. But when that person comes into our domain,
Right.
our rules are applicable, which requires that they have some form of licensure to view our people.
Yeah,
So
but if they're remote in, I mean, that's common to say, let me remote in and look at your software. Let me look at this. I can see in the future remoting in, so let me look at
yeah, but they're making a diagnostic call on an Alabamian.
John Alabama, but they're making a call that they're not licensee from state of Alabama. They're from
And
Connecticut
that's what Dr.
Washington-
McElwain was saying.
or Washington State.
Right. Is that the whomever, the hyper specialist who's doing the path review for your case
That's exactly right.
needs the permit or license, I apologize, to do that for the Alabamian.
And how are we gonna police that if they don't? Because remoting in, man, it'd be 10 minutes to
I just
go up.
remember doing that.
We can put something in the law that you can't do, but how you gonna police it? That's no bite.
Purpose license is
Huh?
specialized credentials that allows a non-resident dentist who is physically not located
Then,
outside
come on, it's like 50 years from now, they say, well, you have this law because
located
there's no
inside
teeth to it.
telecommunications.
It's most of the laws that you have in place are
450, good for 3 years.
Lasts for 3 years, requires a clean disciplinary record and background check.
Right, gotta be licensed elsewhere, have no disciplinary actions. You have to pass the jurisprudence exam, you pay $450, it's good for 3 years.
But number 4 is
And
different.
that is, it's just what you're talking about.
But, so they can do it for 3 years, every day.
Yeah.
Right.
Yeah. 34,910, and then it's 270, I can't think,
It's 270-X-2-.18, the practice of dentistry across state lines.
right.
So does it even need to be addressed for in-state?
Yeah.
'Cause
Yeah, so-
that's what number 4 would be.
Yeah, I understood your comment to be, what does the Alabamian do for an Alabamian, basically? And yes, because in our statute, we don't have a subdivision or subsect for teledentistry specifically. So that's going to be contemplated or discussed by definition. And then to Cameron's point, anything that you've already defined that you want to encompass in the practice of dentistry would be suited for 34.9, was it 6? Whatever the portion is that's titled, what is constituting the practice of dentistry? Yeah, what constitutes the practice of dentistry is 34.9.6. So you would put in there that teledentistry is a viable method.
And then my next question is, do we even need to go this far in if we've defined it? Like, because I love Dr. McElwain's phrase when he talks about unintended consequences. And if we are already defining these things, do we still need to have subsections?
I would just look back to recent history with Botox,
Okay.
because we had when I met Dr. McElwain all those years ago, the whole start of it was an opinion, and there was nothing formally drafted to that point, and where a lot of that contention was from, at least in my belief, is that people got comfortable doing it. It was an expectation. They got very good at doing it, and we're providing a safe and valid service. And then the board's position at the time was, well, we want to have a statutory authority for you to provide said service. And there was definitely a wires crossed moment of you're taking it, but we were trying to define
We felt like the statute gave leeway, but we never defined with a rule
what the way was.
what the way was.
Exactly. So this is
And
that.
the problem is that medicine saw that we didn't do that, and they began to take issue with it.
That's correct.
We had the opinion for, what, 12, 15 years?
I mean, you had it in 2000.
Over a decade.
Can I throw out a what if, please? Just, and I'm not big on over-regulating anything, I promise. And so just bear with me for a moment. But let's say I'm using Dr. X out of state to do some type of teledentistry, read an x-ray, whatever, and he's not licensed in the state of Alabama for teledentistry or whatever. We have no arms to reach that. But you've got arms to reach me. And I'm the one that used an unlicensed person. It's kind of like HIPAA. If you're using a non-HIPAA compliant company and you have a HIPAA complaint, you can't go, oh, I didn't know they weren't non-HIPAA compliant. That's on you. And I almost think this ought to be on the dentist also if they're using somebody that is not licensed for teledentistry or however we're going to define that in the state of Alabama. But I just want to throw that out there because the person out of state is not going to be touchable, but that dentist is. If that makes sense. And I'm not saying, hey, let's overregulate anything. I'm just saying there is a pitfall there. If we do this and say they have to be licensed, then you can't touch them.
Repeat that. You can't touch them if they're licensed.
No, if they're not licensed. Yeah. All I'm saying is, Kelly, you're out of state. I'm consulting with you. You're not licensed in Alabama. There's a board complaint about the way you read my x-ray. And I go, hey, I was using Kelly Perry's service and she's out of state. Well, I think unless there's something in here that spells it out that the dentist can be disciplined for using a non-licensed person, I'm not even sure the dentist can be disciplined. And I think the patient gets caught in a trap.
Well, couldn't the dentist just be disciplined based on the judgment, regardless of where it came from? It's ultimately their judgment.
That's true. That's
You know
true.
what I'm saying?
Yeah, you're kind of just getting a second opinion, aren't you?
I don't think that it's like, great, you got 10 opinions, but at the end of the day, you decided as a licensed dentist in the state.
Because you're the ones with the hands-on.
Yes, and you're the one licensed in our state that
Good point.
dentist.
Good point. I like it.
And I think it's already solved. Or, so
Yeah,
there's
like I said, I didn't want to make it too complicated, but I just didn't see us reaching that other guy out there.
no, we're not. No, there's no way we can do that.
Yeah, Dr. York, there is a statutory violation saying if you're employing, allowing, permitting any unlicensed person or persons to perform work. So if you define that you regulate teledentistry and you start using them and they're unlicensed, then you're in a violation for using an unlicensed person. So I think you can, it's already there for that part.
Okay, thank you.
All right. Let's see now.
For my note taking purposes, are we keeping Dr. White's 4 and 5? Okay.
All right, are we down to 39, 34, 39, excuse me, 3494? And I was just trying to get all the ETA out of here until we make some firm decision down the road about that.
So that means we would just strike number 3 with Dr. White. So that's okay.
Okay. Now, let's move to the, there was a good question. It was, I think Dr. Talbot wrote this question, and it was about, the board may issue a temporary license to an applicant who has met educational examination requirements and is awaiting final board certification question period between graduation and practice. And you're referring to ADHP?
Yes, sir. That's a huge problem area.
It's because the students, that's the huge problem. Their written tests can be in May and their clinical can be in June. They just choose not to. Like some of them put it off a year, but that's the student. They no longer have to be here to take it. They can go anywhere in any state to take this. The student chooses not to. We've had a lot of that too.
I just remember when my assistant hygienist went through, I thought graduation was like in April. And
Yeah,
I don't
it's like
think
the
she, I mean,
26th.
I don't think she got her license to practice until June. It just left a big gap there, and she wanted her license, so she was Johnny on the spot. But there's still like a good
Right.
amount
But-
of time where we
but-
were down.
If there's,
That's a
okay,
lot of downtime.
okay, but you be real careful about this because some of those girls are waiting a year. Some of those girls are waiting more than a year because they don't want to do it. So if you put this in there, those girls that are waiting a year are still going to be covered because they're technically,
Gotcha.
you know,
gotcha.
so,
And they're not licensed.
They haven't passed the
Right.
test.
I think that the 2 months is, yeah,
Well,
but
I'm
if they're
thinking
waiting
it's
a
just-
year, that's even a temporary license, they've yet to pass a regional, they've yet to pass a clinical. I think that's just something that I don't know that we should open that up to if they haven't passed a written or a clinical. Because then they could, like I said,
There's
I
no
truly
way
think they
you
have
could-
5 years to take it. So what if they practice 5 years on that temporary license?
Well, can you not restrict that?
I don't know.
And it seems that I remember Gina bringing up something about regulatory reasons for that 2-month period. Do you remember that?
I do.
I remember some.
She said that once they turn in their permit, they are no longer regulated.
Right.
Because they are not permitted by us anymore.
Yes.
There's nothing that's why they can't go back in and practice.
Right.
Because there's no way to regulate if something happens because they're not licensed or permitted once they take their
Well,
permit.
and that's where the question becomes, do we want to try to patch that gap with a temporary permit or something, or extending it? I don't know. I kind of think that it's just a necessary evil of the program. The program has to end at some point, which
I
means the
agree.
temporary permit has to end at that point. And there's going to be a time gap before the wheels can turn to get them licensed. And now, that being said, on our end, we should do that as quick as possible. And I think anything 6 weeks or less would be very, very fast and appropriate. And there's going to be a period of time where the person just can't see patients.
Well, we did that this year in April. Everybody, when we voted, everybody that passed the ADHP could take the licensure test. They don't have to wait till May, remember?
As soon as they could get it scheduled.
That's right, that's right. And my staff, I had two, they were the first ones to probably get the license. And it took them 6 weeks because they took it in May. And then the problem is it's in June when they take the hand skills.
Yes.
Right.
And if they don't take it in June, they gotta go to Gainesville,
Yeah,
somewhere
they would
else,
go somewhere else.
somewhere else, that's
Then they
right.
got to wait for the next board meeting.
No,
Correct.
no, no.
Oh,
We approved that, we approved that. So that's a hurdle they will have, so it's on them.
Yeah.
Because if you do that, just imagine that someone graduates from Mississippi or Wyoming and they want to come practice hygiene here and say, hey, I got everything, I'm waiting for to take my licensure test. Well, they're not licensed.
Yeah.
I mean, that's just, it happened to me when I
And,
went to
and
dental
having
school.
skills too. I mean, you
That's right.
graduate and it's not like you get your license from the
When did you
board
get your
just the
license?
next day.
in Alabama.
June 26, 1982.
That's right. And we graduated like in June 1st or May.
And let's not forget assistants can now polish and all the things, so that kind of helps that buffer too.
Okay. I just want to make sure that we talked about it. So if there's anything we wanted to do and I favor any temporary license to have a time limited.
Yes, that's my concern.
If we ever choose to do that, a gap license, then I think that might be a 90-day or something like that. No, Kevin?
It's just, we were all talking about it through the lens of the professions that we've had, engineering, education, law. Yes, there are provisional things you can get in law, but it's different for everything. And I run this through the litmus test of, would you do it for a dentist? Would you let the graduate dentist who hasn't passed his boards or anything go practice on a Monday? And the answer is obviously no.
Okay.
You would wait for them to get their stuff. And I think
You could do it. It would be a heavy lift to do it. And not like the way the lawyers do it. You can get a 3rd-year practice card, your 3rd-year law school, but you have to work under the direct supervision of a lawyer. So you could do something like that, but it would be a heavy lift to come up with a way to basically give them a license, a temporary license.
Well, I just want to make sure we talked about it because it's often brought up. Okay? Excuse me. Let's move down to section 34(9-5), penalties.
Okay, my comment is just, I don't know if this is definitely not covered anywhere, but regarding social media, for example, say there's a hygienist recommending whitening products. They do that all the time now, and they're selling that product through them, or their link is if they're from this state, does that mean that they're practicing without a license if they're a hygienist or someone recommending those products
After 2031, bring that question up
after 2031?
because of the FTC.
Oh, okay. I didn't understand. I don't know that stuff.
I don't know the details, but I know what he's talking about.
Okay. Okay.
Well, it just goes back to the definition of practice of dentistry.
Yeah.
Where is that?
It's the next section.
I was going backwards.
I
Okay.
gotcha. I just,
All right, let's
yeah.
let's consider 34(9-5) in light of 34(9-6). What constitutes the practice of dentistry? All right.
Well, before you go to that, the part that I was concerned about is we've had several people come in and say, hey, these people are practicing dentistry and what are you doing about it? And we're always saying our hands are tied. Do we not even want to consider some type of fine? I know it's a class C felony. We know this, but we don't have.
Who are we finding?
But if they're a licensee,
Yeah, we
we
can't
don't
fine.
have any jurisdiction to fine them anything
If they're not a license.
if they're not a licensee.
Right.
Unless they're a licensee is what I meant to say. And as far as prosecution of a felony, that would fall under.
it's the local DA. So if somebody has a whitening thing, right? Let's say it's not a Mobile, just for sake of argument, whatever. It comes to us, the complaint gets filed, we review it, and then Cameron and I or Don or I would look at it. We would go down to that location, see what's going on, get all that information. And then this board has in the past submitted cease and desist letters that would go to Attorney General Marshall, the DA of whatever jurisdiction, Mobile in this state, Baldwin County. And then a letter to that person, all certified, saying that you have X number of days to cease and desist the function, or there are penalties as enumerated here, up to and including. The experience of it is that the DEA will likely call and say, I'm not, I don't want to do this, or I do want to do this. And that's where the temperature changes, is up to that DA. So.
And it's a vicious cycle. So,
Yeah, because there's a lot of it out there.
yeah, I
You
mean,
know,
at the very
those
least, maybe
people-
have some type of terms in place to share with the DA. I don't know. I mean,
Cameron, is it, or Don, it's not in the cards for us, right? proposed language that would give us authority over people for acts against without a license in the DPA, or is that's not doable? Okay.
I mean, that's what I was asking Don. I mean, because right now, our real teeth would be to go seek injunctive relief, which is sometimes hard because these people shut down the company, turn around, name it something else.
Say
and
they're
open
on
it right back
Facebook and they don't have addresses or,
Because we
right.
Betty Wright that way.
It's interesting. It was, yeah.
Aaron, but we saw conjunctive relief reported back to y'all months about how that was going.
But we can do that. That's why I was asking Don, and maybe me and Don can get our heads together and look at other boards. Is there any other way that we could assert some kind of fine or disgorgement of profits that you've made in the illegal practice of dentistry? I just don't know right off the top of my head. There's bound to be another board that has done something. But as far as anything criminal wise, it would have to be the DAs have sole jurisdiction over it. And we can't jump over there, but if we could do something in the civil lane, we just have to
Can't
see.
really do that. We can throw people in jail.
Yeah, I was about to say, we can't do that. They're jealous over there about their authorities. But I will tell you to address the issue, especially if it continues to become a problem and every DA is different. But if it's something y'all want to do, y'all just need to take an active interest of having your investigators or your attorneys start going to these DA conferences, meeting with the DAs. If you create the relationship there and they get more comfortable with what y'all are doing, what y'all need, they might take it more. It's just hard if you go into Jefferson County and they got their hands full.
Going cold.
And then this thing shows up out of nowhere and they've never done a dentist case. They're just, reality is they're just not going to touch it. But if you have relationships built, it makes it easier when they trust that you're giving them everything they need and they can go prosecute it and kind of make it smooth. So it would just be kind of a process to build. If it's something that's such a big problem, we need to start addressing.
I agree, Sonia. And what we have to do is give the DA really the case and let them just do it, because we have to do the homework. They don't have the power, they don't have the time or the money. We have to do everything and say, here it is.
And if Don is going to the American Association of Dental Boards thing in October, they have a legal roundtable there. And you can make some contacts there, because some of the things you hear will scare you to death. That's going on out there. But I mean, I'm serious. It's crazy.
That's a great point, and I'll do that. I'll definitely have those discussions to see how other states are handling it.
Yeah.
All right.
I think my point, 34-9-6, I don't know if this was important, but it just pretty much states mostly what practice of dentistry. It doesn't really list a lot of what dental hygienists do.
It's the same thing.
Okay.
It's the practice dental hygiene is the subset difference of the skills of dentistry.
Okay.
Okay, let's go through these from the top to the bottom. The first one is what performs or attempts or professes to perform any dental operation or dental service of any kind gratuitously or for a salary, fee, money, or other remuneration paid or to be paid directly or indirectly to himself or herself, to any person in his or her behalf, to any agency which is a proprietor of a place where dental operations or dental services are performed.
I think I was just wondering if that needs to be, I guess, quantified in any manner, or if it just needs to stay broad as it is.
Well, number one is in its broadest form.
Yeah.
So
Just,
I like
I
it
would say
broad.
leave it alone.
Okay.
Yeah.
Number two, directly or indirectly by any means or method makes impressions of human teeth, jaws, or adjacent structure, or performs any phase of any operation incident to the replacement of a tooth or part thereof.
We just don't mention anything about scanning at this time. Do we need to?
Well, it says any phase of any operation incident.
Okay.
So,
I think, I guess since it makes impression.
Well, I think the key there is directly or indirectly. So, I mean, that could be interpreted as indirectly making an impression. How, so you're gonna do that besides skin? If we want to actually add that in, I mean, I'm fine with that too. But
Well, I didn't know if it directly or indirectly was referring to who did it.
Right.
Because, if you have an assistant take an impression, that you indirectly had it done.
Yeah. It's a supervision model. I'm reading it as like the
Yeah.
actual how you're doing it.
Yeah, yeah. You see what I'm saying?
It is written that way, that I am directly
It was,
you do things.
that was my memory of it, that it was written like that.
This question about Iteron and that is subsumed later. It's in a broader definition of digital imagery.
Right.
So we'll get that.
And we, number 3 is about, replacing. Number 4 is about,
Dentures.
5, in 5, when I looked at it, y'all, the only thing I was thinking about was, that, down here where it says who surgically or mechanically, who treats surgically or mechanically fractures of the human jaw. Well, actually, it's the human face, because it's, frontal bone to the chin. I mean, including zygomas, orbits, and everything. So we need to change that jaw to face right there.
Yeah, but that definitional report wouldn't count as effects of dentistry because it's not part of the jaw.
Yeah.
Here's one too. Go back to 3 and help me understand why. So take a lab tech. Are they not practicing dentistry under that definition? Supplies artificial substitutes for natural teeth and furnishes, supplies, constructs, reproduces, or repairs any prosthesis or any other structure we want in human mouth. So technically, the way I'm reading that is that anybody that makes a denture is practicing dentistry and therefore is violating Class C health. What am I missing?
The rule. It's the same.
Well,
So it's I'll get there 1 second. So it's the same general piggybacking of what is dental hygiene. It's all of this is under the broader umbrella of dentistry. So then the rule that does this is 270X 3.10, allied dental personnel, and number 1 is actually lab technicians, and then number 2 is dental assistants and hygienists, and then number 3 is just hygienists.
They couldn't supply something to a patient independent of you.
right. I understand that. Okay. So the rule then gets them away from this.
Yeah, let me grab it. I'll read it real fast while you're doing it.
I remember it being in a rule. It just seems backwards to me that the rule would have to match the statute.
Well, maybe what it needs to say, instead of just supplies, it needs to say supplies to a patient.
Yeah, that would do it.
Any.
Yeah.
Supplies to a patient, any artificial substitutes. That's all it needs.
Supplies to-
That's all it needs to say.
Because right now, I'll add that. But the rule says that a a dental laboratory technician, no intraoral duties are allowable other than assisting the dentist in determining, tooth color.
Right.
So they're able to carve out here for this portion, and they're contemplated. And then let me get back to my notes. And you wanted to say what, Dr. McElwain, specifically?
It should say supplies to a patient, because that's what it's inferring. It's not supplying to the dentist, it's supplying,
And it doesn't say
it's skipping the dentist. Supplies to a patient.
I got it.
And number 4, see, covers somebody's like helping you with an all-on-4. Helping you adjust the denture and seat it. Okay.
Yep.
See, that in five, that verbiage midway through the paragraph that says of human teeth or jaws or adjacent structures, that's what gave us,
Botox.
Botox,
I remember that.
okay?
Define adjacent structures, remember that conversation?
I know, that's what I want to make sure everybody was on the same page because I knew where it was going. All right. 6 is repairs or fills cavities of the human teeth. 7,
Just ignore my, just make any comment.
do we need to add anything to that?
I don't think so.
Okay.
Covered.
8 administers anesthetic of any nature in connection with a dental procedure. 9 uses dental surgeon, dentist, oral surgeons, or DDS or DMD.
Change jaws to face
To 10 states.
or 9?
You're talking about on 9?
9.
See, as long as it's got that adjacent structures, I'm comfortable. But when it doesn't enumerate that, when it only stops at jaws, then I think,
Box down.
yeah, get the face.
So we have adjacent structures on the face allocation. Somebody
Adjacent structures / face.
off the base.
So on 5, we could just add adjacent structure instead of changing it from jaw to face.
Adjacent structures of the face.
Yeah, but I would put face there specifically when you're talking about fractures.
Yeah.
Okay, got it.
And then on 9, the last adjacent structures of the face.
It's a physical condition of the teeth or face.
Adjacent structures
I'm sorry, Jason.
Adjacent structures.
of the face.
No, here's the tooth bleaching section.
Just ignore them.
That came about, what was it, about 10 years ago?
Yeah.
Longer now.
I'm
Well,
not
yeah, That was
familiar
the
with all
first
that.
Supreme Court case I participated in. That was 2013.
13, wow.
Which we won. We did. We won that one.
That was the malls. It was self-lighting in the malls.
That was, it was that, and then the lady was offering to step up and then showing you can do it for you. And it's up to her. Which was West Wall. West Walls.
To see Renee's been sent by the FTC to see how we would answer. She keeps bringing this up to see how.
I'm not, no, yeah, I'm sorry.
No, I just,
Yeah, I'm
It
just
was-
not in the
it
know
was
of all of
what it
what
cost.
you can and can't say.
Yeah, but that was,
And that got out wide.
Yeah, Renee.
It could have been worse.
Oh, no, that
$250,000.
Yeah.
And then since, and then there's a teacher came down. But something they do. You go to an institution to. Well, this was good in school, but now he's got more hours.
What's 11 need to say?
On 11, we specify University of Alabama School of Dentistry and other such dental colleges, hospitals, institutions in Alabama. I'm saying, what about institutions out of state that are accredited?
it says or other such dental colleges, hospitals and institutions in Alabama.
In Alabama, right. But what happens if I'm under TMJ curriculum and Kentucky is the one doing it because Alabama doesn't have the program?
Hmm.
No, they're doing it in Lexington.
All this is saying is what constitutes the practice of dentistry in the state of Alabama. So they practice it solely.
No, yeah, but taking, who are taking courses, instructions in University of Alabama School of Dentistry. So are we limiting?
Yeah, because they have to be with the state doing something for us to put our hands. That makes sense.
No.
It's like we're saying it's illegal to practice dentistry in the state of Alabama. You have to actually be do it for us to have it as a jurisdiction. I think that's what we're just talking about. What number are you?
It says we're taking courses, instructions at Liberty School of Dentistry, which are college, you know.
That's getting you ready for the ability for people in dental school right now. In our state.
It's saying that it's okay for a dental student to do dentistry as long as he is within the facilities of the educational institution. That was the big part of this.
So it's okay for them,
And under the supervision of,
like the Dothan Clinic.
Huh?
Like the Dothan Clinic, it's okay.
Right.
Because it's under
it's
the
okay
umbrella of
of UAB.
the School of
Right.
Dentistry.
It's okay for those dental students to be down there being supervised.
Okay, well, we got a problem. We approved Lincoln Memorial to come to Alabama. Didn't we? I don't know, they can bring their students.
If they bring it here, then they're back into the state. They would have to be institutions approved by. So-
Right, we approved that. We approved by the board. Okay.
Right, so it fits this.
Okay.
Yeah, because it's in the state.
Okay,
But it's got to catch on.
all right,
We couldn't approve something to be done in Atlanta.
right.
That's right. Since I ended up being in Georgia.
Yeah.
That's why.
Well, they approved.
All right, and 12 is to leave alone.
Uh-huh.
Are we leaving? A little bit of comment tomorrow,
You're talking about 11 or 12?
talking about 12, there's a letter of comments. And are we just striking the whole thing rule? And Dr. White's? Yeah. I'm specifically talking about Dr. Alvin's portion. I want to know. If you want to talk about announcement. This.
Well, okay, let's get one broad topic on the floor and over. Dr. Talbot, in here, you address some things that I think are important, and it's about anybody affecting the discretion of the dentist to do what he thinks is best for the patient. We really and truly, people getting PPOs and then they sign a contract and then that contract sort of starts defining what are the things they pay for, which ends up guiding what people get and indirectly influences your decision making. And so the question I'm asking, is there anything that we could do that would help the dentist to push back and say, no, this is what's best for the patient?
What about, like what we were trying to pass the bill, the dental loss ratio? Is there anything, because that affects more than just, people on insurance plans, that affects the patients and how much coverage that they have.
Yeah, the question I'm asking is, do we have any?
I don't know I'm just, those are comments of,
Provision, it's not the DPA. But so the point here, if an insurance company does not pay for service, it cannot control the fee. That's already in statute in Alabama. It came around in 2011. So you have examples in Texas, Oklahoma, Tennessee, and Georgia. That's also true for us.
Okay.
So, and I found it. I'll send you that statute, but this is just, I don't mean to make you wrong. but
Non-covered services.
Yeah, what is it? Yes, for non-covered services, and I'll explain that in a second. But the point here about Alabama does not have a strong statute like this. We actually do, and I'll send it to you.
Okay.
Now, when it says non-covered service, what that does not mean is when somebody's maxed out. Because if you're maxed out, it's still considered a covered service that you just are no longer applicable for. So the two things that are considered non-covered are if it says that explicitly in the policy, or if it's covered at 0%. Okay, but if there's a termination, like a duplication of benefits, or a max clause, or a waiting period, all that stuff, that does not apply to the statute that I have that allows you to charge whatever you want. So you still are abiding by the contracted fee if you have a negotiated PPO contract with them.
And age doesn't apply to that either. So if you want to do something like a sealant and they aged out at 15, it's still a covered service even though you're 30. It's a covered service and you aged
Oh, I
out.
didn't know that. Okay.
So non-covered, if it's covered under that policy for any age, it's a covered service. And just because you're too old to have it, doesn't make it non-covered. So that doesn't apply either.
Mark, you said, what can practitioners licenses do? All you have to do is work under price control. When we sign a contract, we agree to price control, and we're talking about the problems of price control. This is the only industry that we have price control. You buy a tire, you buy food, you buy clothing, there's no price control. Healthcare, with medicine and dentistry and optometry, we're price control. And this is a broad issue that we cannot solve, but we can educate, saying, is this what we want? So this is the consequences of price control. And it's going to get worse because inflation hits it. And reimbursements are different. And they're always trying to do that.
But the question I was seeking from the legal eagles is there anything that we can modify in the Practice Act that would aid dentistry in this realm?
I don't think so.
Yeah, in any form or fashion.
No, we can't because that's,
We agreed to it.
yeah.
Which I will try to look it up and I'll work with Don and whoever the general counsel is coming on, the new one comes on, but it's the only thing I have I can see the problem is, well, you're not forced to do anything. You can tell them no. In the end, you're agreeing to go into a contract. And I don't know. We'll just have to figure out. There's got to be some kind of way to provide help. But
What about,
even though if I know you're getting strong armed into the contract, but you're still agreeing, you have the right to say no.
what about when, just another example, when you're out of network fee for service and then that insurance company won't pay anything towards your claims because because your provider was out of network or fee for service, or they reduce what's covered because you're not going to an in-network provider.
Well, if you're out of network, then you aren't bound by anything. So if the patient chooses to come to you,
Correct. But it's just a disadvantage to the patient. I'm just saying, is there anything that, I mean, I'm just looking for anything that would help the patient.
the insurance company's not. But that's how they protect themselves. That's how they keep their costs so low. That's how they force you to go to an in-network provider. But it's just, you would have better chances with your insurance commissioner and getting him on your side than you would trying to
It
talk to a
sounds like,
patient about out of network.
it sounds like we need good legal advice on this, because what we're facing now is the insurance companies are stopping the dentist from making good clinical judgment, and that protects the
Dictating treatment
patient.
plan.
So the thing that y'all are talking about, are not really in the Dental Practice Act.
Correct.
They're in the insurance part of Alabama. So those things like our loss ratio legislation is a different part of the law we're addressing. So, I mean, I don't see anywhere in the Practice Act where we should address anything like that. But, what you were saying, Dr. White, I mean, Dr. Piszczek is right. I mean, it comes down to a matter of a choice to become a provider and sign a contract that binds you to adhere to everything in the contract.
Well, I understand
It's not being a provider.
all of that, but why are we 51 out of 51 states in reimbursement when other states are able to protect themselves? Why are we 51 out of 51? Because now we've gotten into an access of care issue where dentists no longer want to practice in our state. So to me,
It's a
you know, the
public-
safety of the public, it's become a safety, access to care issue. So I'm just trying to figure out if there's something, any form or fashion that,
Yeah.
because we're literally the worst reimbursed state in the whole country.
I'm not seeing, as I said, there's a case of first impression for me, and this is another thing that I'll discuss up there at the board conference. I don't see any way to go into the Dental Practice Act and address this. I don't see any way. This is a political discussion. And as Dr. Piszczek said, it's just kind of a competitive, with the laws of competition and negotiating contracts and that type of thing. As I sit here, I don't see any way to address any of this in the Dental Practice Act other than what Dr. Gray said, which is very educational for me about, about.
Let me read that
Yeah.
statute.
Yeah.
Sorry, it's 27-19-8-12, subsection B. An insurance policy plan or contracting or contract providing for third-party payment or prepayment of health or medical expenses issued after January 1st, 2016 shall not require a dental care provider to provide service to a covered person at a fee set by the policy or plan unless the services are covered by the policy or plan.
What's that statute again?
27-19A-12.
Yeah. And I do think the Department of Insurance is another potential avenue to explore, but I don't see anything in the Dental Practice Act, but I'm glad to know about that statute.
You know, if we don't want to get this passed, let's try to put it in there, and then it's just gonna get shot down, because they're not, the legislators are not going to ask anything. Well, we've got purview of the license, bottom line.
Correct.
And that's gonna be it. And we're not gonna have purview over the insurance companies or anything else. And unfortunately, the bigger fault, Renee, is the bigger fault. We point our fingers about 90 miles south of here, and all those people sitting down there.
Yes, but do
I
we
understand.
risk our patients? I think
Exactly.
we might be missing a big point here, because when insurance companies tell us, hey, we can't take x-rays to diagnose our patients, that to me is
No, they don't tell you you can't take them. They say you won't pay you. There's a difference.
But then we're the
And if you
villain.
take it, it has to be the price that you contracted with.
Yeah.
And that's awesome. When we talk about insurance,
You see,
insurance.
there's a dilemma.
Well,
Most of these companies are not insurance companies, they're management plans, so they come outside the jurisdiction of insurance companies. So we gotta educate the rank and file people. I mean, you said the insurance commission, no. Are those individuals working as a dental plan or dental management plan? Because all of us here can set up a,
Management plans.
All right, here's how you fix it.
how you fix it? How you fix it?
Here's how you fix it. You put in this Dental Practice Act that when you rotate off the board, you have to run for state legislature.
yeah, I was putting up hold.
Mark, you're up first.
Yeah, Roberto.
Yeah, Roberto, you're.
I just wrote the check.
All need Montgomery, fix it.
That's honestly what it's gonna
That's
take.
what's going to take.
Well,
Well,
the reason I put that broad question out there is that, there's the place in the Dental Practice Act, and I forget 34, whatever it is, where it says that nobody's allowed to interfere with your professional judgment. And I was just wondering if there's anything quickish we could do to augment that.
Right.
Essentially what you're saying is that you're allowing them to dictate your mind. They're not telling you to do anything. They're just telling you what they're offering.
What they're gonna pay for.
Right. You're allowing that to cloud your decision-making process.
And see, a lot of the contracts, Dr. White, to your point, they would say, okay, if I decide we're gonna pay for one particular type of radiograph. And so I decide to do another CT to look at something. Well, we're not gonna pay for it and you can't charge for it. And there's where the rub comes in.
Well, you can charge for it, you just have to charge a contracted fee.
But you know if there's a limit.
Yeah.
You're an HMO plan, you're a certain plan, you are signing up a lot of those contracts not to charge at all.
Okay, well, that's an HMO plan. There's
Well,
tons
there's
of
other
others that say.
That have limits.
Yeah.
So they say you can, a Panorex every so
Yes.
often or a
Yes.
3D CT.
Yes, that is their limit. They're gonna pay for it once. But if it is medically necessary or you say it is necessary, you can charge a patient. You just have to charge them what the insurance company pays.
If that
It
plan,
depends on if they allow that.
they'll have that in the contract. Get rid of the contract, fine print.
My suggestion.
The
would be
balance
they
billing
go out of
thing is
network.
what's killing us now.
That's current balance.
Yes, ma'am.
Best idea is to be a member of Outland, encourage everybody to be a member of Outland. So we have 75% or more of the dentists in the state who are speaking collectively to the legislature. And everything y'all said is totally true.
Yeah.
It's just a different animal.
Yes.
Dr. Fan?
To interrupt, but we've got an issue with Dr. Taylor Smith, coming for the volunteer for Shelby, and she needs to have it approved today so that she can start work tomorrow.
Is that
It's on our agenda for tomorrow to approve,
okay,
and we just need to move her because they just called.
okay,
So it should be
okay.
approved today.
Do you want to go until 3:00, take a break, come back, and be done?
All right, that'll be fine. All right. All right, I beat that horse to death.
It's two.
All right,
I think I'll start making comments after that.
I still think we should be able to do something.
the mobile dental facilities, I mean, that thing has been hashed over so many times.
One second, sorry.
At 3496,
I understand, 6.1, but in 6, are we considering or keeping Dr. White's comments? I have notes for Dr. Talbot. I don't have notes for Dr. White. Dr. White has portions listed, starting with number 13, utilizing the electronic, digital, or other communication technologies, including teledentistry, to diagnose, consult, provide treatment, planning for a patient located within the state. But anything that you want to keep, just please let me know, then I'll make notes of that too. Yeah.
Dr. White, you
I think I was hoping we could do is just define teledentistry more like when how we're defining it in 1 through 12. And we don't have it in 1 through
No, for consideration, a broad definition would be in definitions in chapter 1 or part 1, sorry.
Right,
And then-
but
and
define it for dentistry. So, like, okay, so
Sorry,
if
I
you
didn't-
read,
I said, I'm sorry, I know I looked at you like that was crazy. but
yeah.
I,
So when you read 1 through 12,
Mhm.
they break it down. And then so on 13, it would just be breaking it down, saying, okay, we're going to utilize the electronic, digital, and other communication technologies.
I may be missing the mark a little bit, but do we need to be careful here about phrasing this for a person within the state to use teledentistry within the state due to the application of the special purpose license? In other words, is it appropriate for somebody in Mobile to, I think the intention is that I could call Dr. White and be treated through teledentistry in Birmingham, which is fine. But what I'm trying to avoid, where my head is going, is that we have that special purpose license for somebody outside. And I'm trying to make sure that all of these are for people within the state only.
Couldn't the intention also be that if we go to general supervision, Dr. White can look at something that's been sent to her from her staff? Couldn't that also be
Also,
teledentistry?
there's ortho that's done through teledentistry now.
Okay. 13, 14, 15, we want to try to add them to that.
I did, but I mean, now I'm kind of thinking I was too much. Like, we're trying to be a little more broad, and I'm being more specific. So I don't know.
Kevin, why don't we take 13, 14, 15, let's write them up as we think that they would add to this statute, and let's look at it, and next time we come back, just take it and let's work on that. And we'll look at it. I mean, we may trim some of it out. All right. The mobile dental facilities and portable operations is pretty damn comprehensive, isn't it?
I wouldn't touch it at all. It seems to be doing its job. I mean, I don't see a lot of complaints coming along through those avenues. And I think it was, didn't all this come about from about a decade or 15 years ago? There was a big push for mobile.
20 years ago, they were going to put them all over. Yeah, people were going to run them, and people got a little scared that they just swoop in and do the dentistry and leave and go to the next 50 miles.
I think it was more like early 2000s. Surreal came along.
Mm-hmm.
Yeah, and then all this got added in, and it really kind of went away. And so I said we just leave all that around. I don't know who wrote that piece of legislation. That was a beast.
Well, you know, there are electric cars now that when you say that has to be fully charged. That's really the only thing that's changed.
We have a young man who actually wrote that statute here. But
Everybody stay.
Yeah.
Only the people that
but that's the last comment we have for this section of the Dental Practice Act.
Yes, sir.
Today.
I anticipated that we would get through about half of it. That means that half of part one is still left for the future, which is fine. If we want to take a break and we want to do, thank you. If we want to do a break and then have more, happy to print out more. If you want to take a break and come back and then do the licensing and the cases, that's fine too.
Let's do that.
Roger that.
Break now. Break. The Board of Dental Examiners, we're back from break. Dr. Finn, you had an item that was going to be brought to my attention.
Dr. Taylor Smith, has a volunteer license application, and she is participating in the Shelby, session event tomorrow. And, she thought she wasn't gonna go until, Saturday, but we need to go ahead and give her approved so she can, work tomorrow.
Okay, and she is licensed in good standing and all proper.
Yes.
Do I hear a motion?
Motion.
Motion by Dr. White, second.
Second.
By Dr. York. McElwain, yes.
White, yes.
Peace, yes.
Yes.
Peace, yes.
Talbot, yes.
Abstain.
Unanimous consent with abstention of the hygiene member. It is approved. All right. What are we doing now, Kevin?
I think we're doing executive session for litigation and cases, and then we'll come back and do votes.
Okay, do I hear a motion that we go into executive session for discussion of pending litigation and cases?
Motion.
Motion by Dr. Talbot, second by Dr. York. Roll call vote. McElwain, yes.
York, yes.
Peace, yes.
Talbot, yes.
Perry, yes.
Very, yes.
Do we have proper?
Yes, and as a member in good standing with the bar, I certify that we're going in at least partially into executive session for pending litigation.
Thank you. We're in executive session. Back on, session. Let's see, we have 2664 before us right now. Dr. Piszczek?
No evidence.
We have Dr. Piszczek, no evidence to sustain. Do I hear a motion?
Motion.
So moved by Dr. White, second by Dr. York. All in favor?
Right, yes.
McElwain, yes.
White, yes.
York, yes.
Piszczek abstains.
Talbot, yes. Perry abstains.
All right. So 2664, no evidence to sustain. 2654.
Yes, sir. That was recommended no evidence to sustain by Dr. Gray.
Dr. Gray recommends no evidence to sustain. Do I hear a motion?
Motion.
Motion by Dr. White, second by Dr. Piszczek.
Abstain.
McElwain, yes.
White, yes.
York, yes.
Piszczek, yes.
Talbot, yes. Perry abstain.
Okay. 2676.
That was recommended for notice of hearing by Dr. Gray.
2676, recommend notice of hearing. Dr. Gray abstains. McElwain, yes.
White, yes.
York, yes.
Piszczek, yes.
Talbot, yes. Perry abstain.
Okay.
Do we need the settlement terms of that built into the vote? Or no?
If you want to classify that recommendation as settlement.
Yeah, so the recommendation with the notice of hearing is a settlement of voluntary surrender of license.
Okay. 2676, notice for hearing and voluntary surrender of license, if he wishes to settle. McElwain, yes.
White, yes.
York, yes.
Piszczek, yes.
Talbot, yes. Perry abstain.
Okay.
And then abstain.
And I abstain.
Okay. And then
Okay.
we do a conflict check on that one. And that is Dr. Douglas O'Connor out of Evergreen. If anybody has issue with that. And then the last thing is that, Dr. York, I think you had, a point made about recusal.
Yes.
I have the case number. So this will be in the matter of 2653.
In the matter of 26-53, upon reflection upon my previous statement, I have decided now to recuse from the hearing for that case number.
After further review, I've decided to recuse from 2653.
After further review, I have decided to abstain from 2653 as well.
All right. Dr. McElwain, I'd appreciate a vote to accept the terms from those board members and then authorize me to contact a list of board members and I'll name them.
Okay. I'm placing a motion on the floor to accept the recusal of Dr. White, Dr. York, and Dr. Talbot in the matter of
Case number 2653.
2653. And under board rules and board policy, the following former board members will be offered the opportunity to reconstitute a full quorum for a hearing.
Right.
They are.
I will contact Dr. Jones, Dr. Marshall, Williams, Dr. Bruce Cunningham, Dr. Kevin Sims, Dr. Adolphus Jackson, Dr. Sam Citrano, and Dr. Steve Strickland.
Okay. That motion is on the floor. Second. Second by Dr. Piszczek. Holt?
Yes.
Dr. Gray, yes. Dr. McElwain, yes.
Dr. White, yes.
Piszczek abstains.
We vote? Since
Yes.
we're- Okay. York, yes.
Talbot, yes.
Perry abstain.
All right. The matter is carried. Are there any more issues to come before the board? Okay, I'll adjourn us to tomorrow morning at 8 a.m.